My lord, the concept which is going on, what is the significance and sanctity attached to the office of the governor? My lord, that we come to know from the Constituent Assembly debates. My lord, it's not, my lord, an asylum for retired politicians, as, my lord, we understand. It has its own sanctity. And, my lord, the framers of the Constitution have debated on it, that why we need governor, why we need governors with the powers which we are going to confer upon it, and in the federalism which we have adopted, as against, my lord, the absolute federalism in United States, where each state or province has its own constitution, has its own Supreme Court, has its own, my lord, way of governance. We have not adopted that.
Even dual citizenship.
The dual citizenship. So, my lord, they have examined that center will have to play a role in the governance of the provinces, which is now states, and that is how, my lord, the position of governor is conceived. Lord, please have a look at page 128. Lord, section 46 is the peri materia provision, or, my lord, if I may say, the precursor to the present 155, where the governors were appointed. Lord, page 128 bottom, Government of Bengal, Madras and Bombay. The presidencies of Fort William in Bengal, Fort St. George and Bombay are subject to the provisions of this act, governed by the governors in council of those presidencies respectively, and the two former presidencies are in this act referred to as the presidencies of Bengal and Madras. Then, my lord, comes 35 Act. My lord, initially the idea was that the governor should also be an elected person, so that he also wields the same democratic sanctity, and which is rejected by the framers of the Constitution. I'll show that, my lord. Section 48, my lord, 1935 Act, again, my lord, the colonial era act. The governor of a province is appointed by His Majesty by a commission under the Royal Sign Manual. The provisions of the third schedule to, my lord, not relevant. Yes. Now, my lord, I am on interpretation of Article 200 and 201. Please come to page 150. Let me read it, my lord, the way we believe it requires to be read. 200, assent of the bills. When a bill has been passed by the Legislative Assembly of a state, or in case of a state having Legislative Council, has been passed by both houses of the Legislative Assembly, it shall be presented to the governor. So this is the first condition. And the governor shall declare. This is his obligation, constitutional obligation. He has to make a declaration. What? 4 options. Either that he assents to the bill, or second option, he withholds assent, withhold assent therefrom. Third option, or that he reserves the bill for consideration of the president. I'll come to, my lord, Article 254, which says that this reference would be necessary only if the bill is repugnant to some central law, not otherwise. He cannot refer it for any other reason. That
referring to the president.
Yeah, then he can refer it. He has to refer it. That's the mandate. My lord, if there is a repugnancy with the central law, he will have to refer it. Now the fourth option, provided that the governor may. It doesn't say shall. Governor may. And something would turn when my lord, point out.
Mr. The 1 minute. Let's read it again, the first part.
I'll read, my lord. When a bill has been passed by the Legislative Assembly of a state, or in case of a state having Legislative Council have been passed by both houses of legislature of the state, it shall be presented to the governor.
Right.
And the governor shall declare either.
Yes. So declaration has to be in both cases, whether he assents or whether he withholds.
All 4 cases.
No.
All 3 cases.
Yes.
Yes.
That declaration has to be there.
100%.
It is not that he will not make a declaration and withhold it.
Yes, he will have to declare that I have withheld it.
Correct.
Bound, I bound out. That is the only way it can be read. Yes, he has to declare. One of the 3, he will declare either first option, he assents to the bill. Then no dispute will remain. The governor is supposed to act on the aid and advice of the Council of Ministers generally, unless, my lord, the question of withholding comes. Why I say this? No Council of Minister would say that my assembly has passed a bill, you please withhold it. My assembly has passed a bill. There are circumstances where the ministry would advise that you refer it to the president. And I'll tell you, Lordships, why. There are certain provisions which I will show where presidential assent is mandatory. It is not at the discretion of the governor. And therefore, it will be in the interest of the ministry, the Council of Ministers, to advise the governor that you please take assent of the president. Otherwise, my lord, for withholding of the bill, there would not be any question. And unless, my lord, that is read as a discretion conferred upon the government, my lord, upon the governor, my lord, there are several situations, my lord, I'll come to, which will not be able to, my lord, reconcile with the constitutional scheme. Even the ministries, the Council of Ministers can request him to withhold. Lord, please take pre-10th schedule scenario where there was no whip. Correct, my lord? There is a Council of Ministers consisting of 15 people. They lose majority and a bill is passed in the House which is not of the liking of the Council of Ministers. There was no 10th schedule, my lord, prior to 85. And we are dealing with Article 200, which is since 47. Maybe the council may advise him to withhold, saying that this is, I am not agreeing to this. And he may, in his discretion, can still say that no, it is passed by majority in the House. You may not enjoy confidence of the House, but it is passed by the House. I will grant assent. Or he may, in his wisdom, call the chief ministers and say that I am returning it to the House. You go and convince your people. That is where, my lord, his statesmanship comes. Lord, what we are, my lord, undertaking an exercise is that a rogue governor would act in this particular fashion, and therefore we have to interpret in such a manner that he cannot act in this fashion. Therefore, my lord, I am repeatedly requesting the Honorable Court, and my arguments are molded accordingly, that consider an ideal situation and interpret. Lord, keep possibility of abuse in mind.
No, but we quite appreciate your submission that when a power is vested with a high constitutional functionary, it is to be presumed that the power will be exercised properly and in a bona fide manner. And we can't proceed on a presumption that the power would be
everybody would misuse, or in all cases it would be misused.
Or an possibility of the misuse of power cannot be a ground to challenge the validity of a power.
Or even interpret it differently, my lord, if the intention is very clear.
Don't be under the impression that we are asking because of the prejudice in the way the governors are acting. That has got nothing.
No, I'm very
That's
confident.
the proposition. That's
My lord, it is that confidence, my lord, with which we have come before your lordships, that please advise us.
You are also not aware about
How the governors
are acting.
Yes. Well, there are several situations, my lord. These are all political issues, and my lord, I'll come to that as a legal proposition.
So therefore, at least I always say that let this not be a battleground for political. We will decide, we'll interpret the constitution as it has to be
And
interpreted.
my lord, there are several issues where the solution lies elsewhere. Every problem need not be and cannot be solved by the third, my lord, one of the organs, namely the judiciary.
Third chamber.
No,
Like Pandit Jawaharlal Nehru, while introducing 31A and 31B, they said that when we determine the compensation in order to advance the social and economic justice,
court will not go into it.
we expect that the Supreme Court and the High Courts would not act as a third chamber.
Third chamber, yes. No, in fact, thereafter it was prohibited also that the court cannot go into.
Yes, but then that been set aside. That those amendments have been set aside not once, but twice.
But, the executive or legislature has never been permitted to encroach upon the third organ of the state. I leave it at that.